did file this motion 16, style motion to protect defendant's right to a fair trial by limited closure of courtroom for pretrial motions. I filed that last week, Judge. I did serve a copy directly to your office along with some exhibits. In a nutshell, Judge, what we're asking for in this case is a limited closure of the courtrooms for pretrial motions where prosecution evidence is expected to be discussed or disclosed. The reason why we filed this, essentially what our concerns are in a nutshell, is because of extensive press coverage in this case and local interest, national interest. All contested evidence and argument that we would deal with as a matter of normal course in pretrial motions are going to become public domain. All that information is going to become available to any juror, any potential juror in this community or anywhere in Georgia that's got a television, internet, or smartphone. What could that include? That could include any and all evidence which the court may ultimately exclude from trial, including the court could suppress evidence unlawfully seized. We have filed suppression motions. The court could exclude certain evidence as more prejudicial than probative. That's an extremely common argument that we make in any case. The court could agree to redact certain statements or recordings which are preliminarily deemed admissible. That's certainly not uncommon. It could include pretrial matters that the court ultimately deems not relevant for trial. So as we work through pretrial motions, all of this is any material, any prosecution evidence that is disclosed is going to be public domain. And it doesn't matter if the court ultimately excludes it, suppresses it, limits it, finds that it's more prejudicial than probative, redacts it, finds that it's not relevant. It's already out there. The big problem, Judge, that I see in that kind of disclosure also is that the contested evidence is going to first enter the public domain affixed to commentary, opinion, analysis from the press, from entities that, quite frankly, Judge, they're looking to sell papers, or they're looking to attract viewers. And let me say at this point, this certainly isn't my intent to bash our local papers. I take them every day, the Journal, I take the Atlanta Journal. I really made that. I certainly watch CNN and other national programs. That's not the point here, Judge. But when the prosecution evidence first comes into the public realm, affixed with that kind of opinion with it and commentary, it does have an effect on potential jurors. Another concern that we've got, Judge, is that the pretrial matters, evidence, prosecution evidence, which comes into the public domain through pretrial motions, are also going to be affixed to the court's rulings. Those rulings are likewise going to be recorded. So what the public is going to see and hear is any and all contested evidence through these pretrial motions, and then they're going to hear about the court's rulings. And there's no way that can't stamp the imprimatur of the court onto those contested matters. This is before we ever start picking a jury. We're concerned about negative reporting from the disclosure of evidence pretrial out of context. Normally, a jury gets evidence at trial. And it's in context of all the other evidence. Here, if measures are not taken to curtail the disclosure of everything, this case is absolutely going to be tried in the media and in the court of public opinion before we ever attempt to strike a jury. I would submit to the court that negative reporting has effectively shifted the burden of proof already in this case. It doesn't take a lot of effort to look at the stories and articles on the internet and Facebook and through the newspaper and see that Mr. Harris has already been condemned. Certainly following a very well choreographed probable cause hearing. And if measures aren't taken to curtail the disclosure of prosecution evidence before trial, then Mr. Harris is effectively going to have to prove his innocence. And that's not how the system is set up, Judge. The burden should not be shifted by virtue of disclosure of everything before we ever get to trial. So what have you got to decide here? Well, we know that Ms. Harris has a constitutional right to a fair trial. I think, I don't want to speak for them, but I believe that even the lawyers for the press would agree with that as a starting point. Both the U.S. Supreme Court and the Georgia Supreme Court have recognized that in some instances, pretrial publicity can unconstitutionally prejudice an accused right to a fair trial. Both of those courts have recognized closure of the courtroom in criminal cases, in particular pretrial matters, preliminary hearing, can be an appropriate and is an available remedy. Both courts have authorized closure, Judge. And even though the press and the public may have a qualified First Amendment right under the U.S. Constitution, and under our state constitution, I want to read that directly to the court. I'm certain this is going to be addressed. Judge, under our state constitution, there's a provision, Article 1, rights of persons, paragraph 11, provides in part that the defendant shall have a public and speedy trial. A lot of the cases address this, Judge. But what I want you to consider is that this constitutional provision is sort of our state counterpart to the Sixth Amendment. What it's talking about is the right to a public trial, personal to the accused. Shall render judgment without the verdict of a jury in all civil cases where no issuable defense is filed and where a jury is not deemed demanded in writing by either party. In criminal cases, the defendant shall have a public and speedy trial by an impartial jury, and the jury shall be the judges of the law and facts. Notably, Judge, there is a provision in the state constitution, paragraph 5, that deals specifically with freedom of speech and freedom of the press guaranteed. No law shall pass to curtail or restrain the freedom of speech of the press. Every person may speak right and publish sentiments on all subjects, but shall be responsible for the abuse of that liberty. It certainly doesn't indicate that the press and public have the right to be in any particular courtroom for a criminal case. I would ask that you consider that. Ultimately, Judge, the courts agree, however, that there does exist a balance between the accused's constitutional rights, right to a fair trial, and public policy, as well as qualified rights of the press and public to open courtrooms in criminal cases. Both courts, U.S. Supreme Court and the Georgia Supreme Court, correctly conclude that such measures should be the exception, and in rare cases, and we certainly agree with that. Our position is that this is one of those rare cases. So what is the standard by which the court is going to have to make a decision? Our motion, as well as the pleadings filed by the lawyers for the press, draw attention specifically to R.W. Page Court versus Lumpkin, 249 Georgia 576. That's a 1982 decision. This is kind of the roadmap, if you will, Judge, that all the other decisions, Georgia decisions, sort of follow. And it's a pretty comprehensive case telling this court how to look at these sort of motions and how to perform that weighing of rights. The court in Lumpkin recognized that the possibility of many possible exceptions allowing closure in criminal cases, but directed that courtrooms remain open unless, and this is the significant language, Judge, the defendant or other movement is able to demonstrate on the record by clear and convincing proof that closing the hearing to the press and public is the only means by which a clear and present danger to his right to a fair trial or other asserted right can be avoided. That's it, Division 4. The court in Lumpkin directed that before closing a courtroom for pretrial hearings in criminal cases, the court is to consider the following remedial measures and utilize those measures unless such measures would not adequately protect the defendant's right to a fair trial. So what is the court asking you to consider? Well, postponing the hearing until we get a jury and they're sequestered, or change of venue, 4, clear and emphatic jury instructions. The court in Lumpkin goes on to direct that the movement must demonstrate by clear and convincing proof that no other means available other than the closure of the hearing will serve to protect the right of the movement. Closure orders shall also be narrowly drawn and strictly construed in favor of open hearings, in writing, fully articulating the alternatives to closure and the reasons why such alternatives would not be adequate, and shall provide a transcription and later dissemination of those portions of the hearing which was closed. So that's kind of the standard, Judge. That's kind of the roadmap for you and how to look at this kind of a motion. We did cite some other cases in our motion that I want to call a few things to your attention. Both the U.S. Supreme Court and the Georgia Supreme Court have stated over and over that no right ranks higher than the right of the accused to a fair trial. At the end of the day, Judge, that is in fact the highest right the court has got to be concerned with. The burden of protecting the accused's right to a fair trial from the prejudicial effect of pretrial publicity falls squarely on the trial courts. So I wanted to set out for the court kind of how it is that you need to take a look at this pretrial publicity. We did submit some exhibits demonstrating some of the media coverage in this case affixed to the motion as exhibits 1 through 11. I'd offer those to the court. Certainly not for the truth of the matter contained therein, but basically it's just a proffer of the kind of coverage that has occurred in this case. In particular, Judge, I want to address Exhibit 1, which is some newspaper clippings from the Marietta Daily Journal, and I want to again stress I'm not here to criticize the Marietta Daily Journal. That is not at all the purpose, Judge. But I do think it's important that the court take a look at some specific things that were reported and how they were reported and what effect or impact that would be expected to have on potential jurors.
Judge, just so the record is clear, we don't object to the admission of this for this limited purpose, the exhibits that he's filed with Your Honor. So just in case that comes up down the road, we don't have an objection. I don't know if the media attorneys do either.
Judge.
Wait just a minute, let's see if they have a problem with your proffer.
Certainly, Your Honor, WSIA, WGCL would object to the proffer of the various and Sunday news media articles and clippings and website links that were submitted as attachments to the motion. It's all hearsay. I've got a couple of case sites if the court wants. I think Mr. Kilgore has conceded as much by his acknowledgement that he's not proffering for the truth of the matters asserted therein, but that doesn't change some of the other serious deficiencies with that evidence, namely authentication as the first hurdle, and then of course he's got to find an exception to the hearsay rule, which we would submit can't be found here. So we would object to the proffer of evidence, certainly given the very high standard of proof that Mr. Kilgore just explained to the court is required of this.
What do you say?
It's not hearsay. I'm not offering it for the truth.
The person.
Your Honor, we would join that objection, particularly with respect to what has been submitted to the court are Media Monitor reports about television reporting, which is actually Media Monitor labeled their description as a synopsis. In other words, it's not a copy of the television broadcast. It's a third party's synopsis of what they say was broadcast in connection with a television program, a television news program. Those media monitor reports have traditionally been excluded by courts in exactly this position because they aren't a copy of what was broadcast. They're somebody's synopsis of what was broadcast. And so it is that in particular is clearly hearsay. Also would violate the best evidence rule. The broadcasts themselves are routinely subject to subpoena and can be submitted to the court directly.
And what would your argument be, Mr. Kilgore?
It's not hearsay. I'm not offering for the truth judge, and the reality is, we could be in this courtroom for 3 months if I just simply replayed report after report after report after report. I'm offering it for whatever value the court may want to give it. It is simply, those are simply exhibits to demonstrate that the coverage has been substantial, for whatever limited purposes the court may want to give it.
I'm allowed the proffer, as proffer, you could state in place your proffer. I don't see it as hearsay because it's not being offered as the truth thereof. So I know the exceptions of all the media outlets that are represented in court. I know that the state has no opposition. I'm going to allow it over the objection of the media outlets that are represented in court. Thank you, gentlemen. Yes, sir, you can continue.
Judge, I'm gonna proceed through these kind of quickly, but I do want to point out a couple of things from some of these articles in Exhibit 1. Thursday, June 19th, 2014, this article is the front page of the Marietta Daily Journal. One concern that we've got is in that article, there is an eyewitness apparently at the scene who is quoting, who is quoted saying, "It's 99% impossible to just forget your child in the car," Smith said, "not unless you meant to do it." Whether or not that is accurate reporting of what the witness said, it certainly is more than a mere suggestion of guilt. And this was, of course, immediately after arrest. I'm not gonna discuss the editorials, Judge. I have included some of those in here. The court can certainly take a look at those. I want to draw the court's attention to the June 24th, 2014 article in the Marietta Daily Journal. The headline being "Police Much More to the Harris Case." And therein, one of the Cobb County police spokesman was quoted offering his personal opinion. He's certainly entitled to a personal opinion. I don't have a problem with that, but what is reported is, he says, "What I learned from my investigators shocked my conscience." And I would submit to the court that that is an example of sensationalism coming directly from the police spokesperson. The article on June 25th, 2014, again, is the headline. It's on the front page of the Marietta Daily Journal. I would submit that the headline, which reads sources, toddler death may not have been accidental, is certainly a comment on legal theories, and it's via unnamed sources. I would suggest that that's certainly sensationalized. And again, the quote from the police spokesperson is repeated in there. "What I learned from my investigators shocked my conscience." That's actually reported in a couple of stories, Judge. The case was again the on the front page of the Marion Daily Journal on Thursday, June the 26th. And therein, Judge, a spokesperson, I believe this was a different spokesperson from the police department, is quoted, "There's a difference between negligence and gross negligence." He said, "The thing about negligence is it can happen to anybody. Gross negligence shows there are some other circumstances revolving around it." Obviously, that's an erroneous statement of the law, but in a comment on legal theories, but our position is, Judge, that kind of reporting obviously could have an effect on public opinion when we know from the warrant, even before the case is indicted, that negligence is going to be an issue. I want to draw the court's attention to, I think, an interesting article on June the 27th, 2014. And this article, Judge, I believe is what I want you to take a look at. Because the reporting here, I think, it demonstrates the impact on public opinion of potential jurors from media reports. And in this article, it's warrants, sources, law enforcement sources, and a spokesman from the police department. A couple of things I noticed in this article. There's a quote. There's a quote about halfway through the article that indicates the Cobb County Medical Examiner believes that the cause of death is consistent with hypothermia, and the investigative information suggests the manner of death is homicide, he said at a press conference Wednesday evening at police headquarters. This is Officer Bowen. He added, the designation of homicide in the medical and legal sense simply denotes a death caused by another. And Judge, I don't know where he got that information, but of course we know now with the public release of the autopsy report that statement is just not true. I've got with me today Judge, this goes to the very information that was subject to the state's motion a couple of months ago, which was the autopsy report, which obviously now that it's public does not indicate that particular finding, and rather indicates that the manner of death could not be determined. So. This is reporting on matters, Judge, that is in the public view, certainly could negatively shape opinion of potential jurors. All right. I want to call attention 11 exhibits.
Judge, I think we're gonna, if it's in the media, that's fine, but if he's tendering this as an exhibit, I don't believe we have a proper witness or explanation other than this front page of the autopsy report. It doesn't explain the other details of it, so I think this is kind of what he's trying to stop with this type of thing, so I would object to it at this point.
I'll offer, Judge, what I've got is the front page of the medical examiner's report. The only purpose of me proffering it at this time is to demonstrate the inaccuracy of the reporting to the contrary. Apparently, I've got a pretty high burden to prove today, Judge, and so I've got this and I proffer it for whatever purpose the court deems appropriate.
Well, I think the motion brings you entitled to make offers. I think the objection can go to my consideration of it. Gentlemen from the press, do you want to be heard or not? You want to join?
Move to join the state's objection.
Okay.
Yes, Your Honor.
Right. I'm allowed to number all those objections.
And just for the
But for very limited purposes, because it certainly can come in as evidence at this point.
And just for the record, Judge, Mr. Clyde was in this very courtroom arguing for the public release of that very document the last time he was here.
I think it's a little different. Y'all can't do tit for tat, seriously.
Okay.
But I think the point's probably taken by them.
Okay.
I'm not going there.
All right. Let me call attention to June the 29th, 2014. The headline there, warrant, father searched internet for child car deaths. That's very misleading wording. Father searched internet for child car death. Well, excuse me. We have had a preliminary hearing where there's been testimony on this very matter. We have had the release of search warrants. And from my review of those matters, there's no indication that Mr. Harris ever told police that he, quote, searched internet for child car death. I would submit to the court that headline and what it suggests is misleading and it is not supported by what has already been released, again, in the way of warrants and testimony at the probable cause hearing. This is the kind of headline and reporting, Judge, that definitely could create a false impression on potential jurors. That refrain is repeated again in the article. During an interview with Justin, he stated that he recently researched through the internet child deaths inside vehicles and what temperature it needs to be for that to occur. That's not accurate. That's very misleading. I want to call attention to July the 3rd. Okay, this was the day of the preliminary hearing. And we've got a quote from a local attorney in here, essentially a well-known local attorney affirming the charges and affirming the district attorney's decisions. If this were truly an accident, I believe I know Reynolds well enough that a consent bond would have been worked out. This lawyer was quoted as saying he had his suspicions about Harris. I've always felt like there is more to the case. And here's my position would be that that certainly is prejudicial and sensational opinion. That's not the reporting of any fact at all. The day following the preliminary hearing, which would have been July the 4th, 2014, I want the court to, I draw attention to the court to that particular newspaper. I don't know any other way to characterize the reporting that day. It is extremely sensational. If you'll take a look at the front page, it's got an incredibly unflattering photograph of Mr. Harris with the quote, "I dreaded how he would look." Other headlines indicate possible motives, car smelled like death. It's very sensational in the way that it's put together and reported. One thing in particular that I think is very problematic and misleading in the article, the detective is quoted as follows. Stoddard said, Ross Harris returned to his car during lunch to drop off a box of light bulbs he purchased during his break. Stoddard added, surveillance video from the office's parking lot shows Harris stopped and turned back to watch as another individual walked by his car before he headed back inside for the rest of the day. That is absolutely false. It is absolutely false. This quote is suggesting that that the detective had testified that Mr. Harris was walking from his car, turned, looked over his shoulder to watch somebody else walking toward his car. That is false. It is false for a lot of reasons. It's false, one, because it's not what's reflected on the video. But the bigger problem is that it's false because that's not what the officer testified to at the hearing. Now, in fairness to the paper, it is certainly what the testimony suggested in the way the officer testified. But it's not what he said. He did not say that he stopped and turned back to watch another individual walk by his car. And of course, our concern there, Judge, is that that leaves a false impression that it's just inaccurate, and potential jurors, potential jurors hear that, and their opinions are cemented. By taking measures to ensure that all contested prosecution evidence is not placed in the public domain, that's going to cure that, Judge. So that's what we're asking for. Now, I'm just going to suggest to the court, without me going through everything which I now know from the discovery, which I did not know at the probable cause hearing, is that some of the reporting in this particular article is inconsistent. I will suggest that to the court. I want to call attention to the article from the following day, which was Saturday, July 5th, 2014. The headline, the sub-headline there is Harris instructed family members on how to collect 2 life insurance policies on son. Obviously suggesting some nefarious motive, some monetary motive, when in fact that is completely misleading as to what actually occurred. what actually occurred was that after Mr. Harris was arrested, his brother and father came from Alabama and met with him at the jail. And his brother was asking questions about, what about your checking account? What about the bills? What do we need to do in an attempt to help Mr. Harris's wife? And after about 30 minutes of talking and questioning, out of the blue, Mr. Harris's brother says, hey, what about life insurance? Do you have any life insurance? That's how that entire issue was actually occurred. And so the way it's reported here, it gives the impression that somehow he has got a plan to instruct everybody on the outside how to get their hands on money. It's just completely inaccurate, Judge. And if those kind of things do not come in through the disclosure, pre-trial for several days in the Atlanta paper. It was on the front page, I believe, on the 5th and the 6th. The article on the 6th is interesting in a couple of regards. One, it chronicles exactly what we're talking about here today, and that is the effect that the reporting on these, the preliminary hearing, the effect that had on the public. The public. Those same people that we are going to attempt to get a fair and impartial jury. The article states in part, it questions, is this a man who would deliberately leave his son to die in the family SUV? In the public mind, yes. Support for Harris has already turned to suspicion on Thursday with just a few words of testimony by a Cobb County police detective. suspicion hardened into loathing. It then has some very, very sensational language after that. It indicates social media erupted with anger and calls for execution. Lock Harris in a hot car and let him die as his son did. No trial needed. I think that, quite frankly, is very accurate reporting by the Atlanta Journal as to the type of effect that the pretrial disclosure of prosecution evidence out of context can have on the public. That article is also very, very problematic for another reason, Judge, and that is incredibly sensational and I would submit intentionally exaggerated reporting, quoting from a website that in which there is no evidence or testimony from the probable cause hearing that Mr. Harris ever visited, ever. And what's being discussed is websites concerning living child free. In part, the article says, a friend from Home Depot testified Thursday that Harris spoke of Cooper almost incessantly, so often that people were tired of hearing about him. Yet, Harris had visited an online forum devoted to discussions of living child-free, police said. Moderators subsequently took over that forum page on Reddit, private. Recent posts on another child-free site, refugees.bratfree.com, include references to Cooper's death and assertions that child deaths in hot cars, referred to by some as, quote, little sizzlers, are emerging not as a series of tragic accidents, but as homicide by parents. Looks like parents will have to get more creative, says one commentator. Little sizzlers are this decade's SIDS. Not one word came out of the probable cause hearing or in the disclosure of any other evidence pretrial judge through warrants or otherwise that even suggests that Mr. Harris visited that particular site, that he was in any way involved with that site. It's clearly incredibly sensational and misleading. Why? Because it not so subtly attempts to link the assertions of that on that site, a site not linked to Mr. Harris, link it with him. The article goes on and discusses at great length the ideal or paradigm of living child-free. Part of the, quote, child-free movement on the internet, which police say Ross Harris once investigated, is quiet and rational place for non-parents to discuss their choices and why they made them. Refugees.bratfree.com has its share of rational discussion, but the site often becomes profane and angry and at best disdainful of parents. Brat-free commentators have developed their own language. Parents are breeders and paranuts. A mother is typically called a moo. A father is a duh or a duddy. Children are kids, K-Y-D-S, although infants may be referred to as loads and toddlers as toddlers. One discussion thread at Brat-Free on Ross Harris is headed, duh, busted for intentional PNA by car. PNA appears to stand for postnatal abortion. Even the angriest commenters on Bradford take pains to point out that they don't hate children and do not wish them harm, and they are outraged that Harris is being associated with the child-free movement. This article is telling the readers that even the individuals associated with this site and called Child Deaths, Deaths in Cars, Little Sizzlers, even they don't want anything to do with Mr. Harris. Said one, lurking parents, child-free people had nothing to do with this horrific crime. It's your kind that murder and harm children. You have kids and decide you don't want them, and expletive like this happens. Incredibly sensational, and incredibly prejudicial. Something that is almost just made up whole cloth, Judge. There was no testimony linking him to that site. And of course, as it turns out, now that we've seen discovery, there's not a whole lot there's not a whole lot out there to this this child-free suggestion. We'll deal with that at trial. I did submit the later exhibits 2 and 4, which are the online articles for the Marietta Daily Journal and the Atlanta Journal. And a lot of those, Judge, are the same or similar articles that existed in the print edition, but I wanted the court, obviously, to know and to understand that those materials are available on the internet for those who don't take the print edition. Brian, are you looking? Okay. All right, so what do I need to do? Can I use this? Can I use this screen? Judge, I was considering showing the court some news clips from CNN. Once I filed this motion, they mysteriously disappeared and were no longer available.
Can I ask for a 2-minute bio break while he's working his technology?
You know. Probably will need to sit out there when you come back, depending on where we are and what we're doing. Bio play? Good, we'll try the body first.
I don't know how to do that. Control it. How do you get up there?
Computer on the screen.
Turn off. Can we turn that on?
Judge, if they're really wanting to show you this, I don't think there's any need for them to actually put it up on the big screen. I think they can show it to you right here if they want to, bring it up to you, so we don't have to go through all this.
I don't have a problem with that. You want to walk up? Sure. Yeah, I don't have a problem with that.
Y'all are on the product, maybe I
And I think they can make it where your screen can actually see it, Judge, and it doesn't have to be shown to the whole courtroom, if that's what we're really doing here.
I'm fine with that too, Judge.
Well,
You're,
I would like to do something, okay? So move along, whatever's gonna be fastest, I'll do.
all right, plug that back in.
Is it redoing?
We're waiting on that. While he's getting that together, Judge, I'm gonna submit, Exhibit 13. I'm gonna prompt this. This is an article, which appeared online yesterday from essentially online blog, clearinghouse type, source called examiner.com. Did you see that, Joe?
Yeah. I know.
Okay.
I'll take a 5-minute flyover.
Sorry, Judge.
As it
I
were.
think we did it together.
Let's call it a 5-minute tech break, okay? I did make fun of you while you were gone. It was excessively rude.
Yeah, we lost our signal.
It's getting the signal, so it's not coming through the cord for some reason.
Signal's connected.
I pulled it out, so it had to be connected to get pulled up to start with.
I never have to go there. This should just, it says it's connected.
It says no internet access, so you have to reboot it, try to get it going again.
I need to disconnect it.
what they use in
I
your
read that
computer?
this morning.
You want me to put it on mine?
No, mine's fine.
No, I mean, I was going through this.
Right, I need to restart this.
Okay, that's fine.
Do I need to save it for comment?
No, it's already saved.
Yeah.
Put them slow and let them do it. Okay. Well, plug this in.
When you get a second, I need you to pass it on this one. You get ready.
On that one. No, you're fine, Maddox.
It's upside down, I think, yeah.
It's been a long day.
Well, it's kind of weird that that's upside down.
I'm good, so it typically is the other way around.
Yeah, typically. Water up here is not a good thing. Go ahead and log in here when you get a chance.
Okay.
So this one's on, right? Have a copy, yes, now we have a copy, that's fine, you don't even have to put a picture in. But yeah, I think before is what we use. I was just curious, I never seen one that goes on vacation.
We're going to
Or we in court. But I can do that card.
What's that, hotspot? Right now, I don't know. No, I don't You ready? Yeah, ready. What's up? You wanna see that? Downstairs? Professor? Are they? So what about, does everybody have their rules correctly? Not bad, Joe. Should go all out. Let me sit where
We're right about the,
where are you gonna be?
it is a VGA connection around, you were right, it's just upside down, and I wasn't looking at it. I should know better, you caught this in my hours. So,
No, I work on them all the time.
very good, very good. I'm good, maybe this morning, I'm good. I'm learning from Mr. Lester, trying to, they got one of them, you can get mine to work, so.
No.
Zero.
All rise. Come to order. You may be seated.
All right, just appoint some court, we might take a look and see.
Judge, what we've done is, we've pulled up Facebook, and I just wanted to demonstrate to the court what kind of information is out there and sort of how information is passed along and available to potential jurors, and any pretrial evidence can be discussed. So all we did was type in Justin Ross Harris hot car. And the first thing that pops up, it appears court chatter. It looks as if perhaps there may be a minute-by-minute update on that site. Well, there's all kind of stuff there, as you can see. What I want the court to notice is that you can scroll and scroll and scroll and scroll. Essentially, well, we could probably scroll the rest of the time we're sitting in here in the courtroom this afternoon, and it continue to keep feeding posts to Facebook, and these, of course, are from a variety of sources. They're from individuals. They're from news agencies. They're from bloggers. Of course, it disseminates information, and then it permits public comment. And I would encourage the court to try this very thing. Simply type those 4 words and get an idea of exactly how this information is disseminated and what kind of comments are out there. And I won't take the next couple of hours just to continue to scroll here. This was just an example on one very simple Facebook search, if you will, that I wanted to bring to the court's attention. Take a look at something else. Right, this was Exhibit 13, Judge. And in preparing for this hearing, I just looked yesterday to see what would pop up when I typed in, basics. I can't do anything about that, Judge. Here we go.
Fast commercialism.
So this is posted yesterday, September the 12th, 2015. It doesn't matter where it comes from. It's on the internet. It's available to anyone who may be surfing online, looking for stories. This could be passed to individuals via any kind of social media site. It could be done through Facebook. But one thing in particular that I want to bring to the court's attention see if I can find it. Right. In this article, Judge, if you'll take a look, it discusses public opinion, which is, of course, something that we're obviously talking about here, and I think that the court has got to look at and consider. And if you see the paragraph here, essentially information that the same cousin, I don't know who the writer's talking about here, also has claimed responsibility for sending Ross a video to watch prior to the death of Cooper Harris. The video of an animal dying in a hot car. This is the background that Ross Harris comes from, where watching animals dying falls on the range of normalcy. The public has a tough time with that. Of course, from the probable cause hearing, as well as the warrants which were released, there's no such thing that exists, that certainly that we've been made aware of a video where an animal dies. And I showed that to the court because I just think that's an example of the kind of information that can be out there. You take a little bit of information that's disclosed, and this is what can happen. Well,
Victor Blackwell is joining me now along with...
okay. I believe that this is exhibit... I believe this is exhibit 10, Judge. It is. And this is, CNN was posting live updates from the preliminary hearing via Twitter from their reporters. And see if you go through, and this is still online, if you go through, they're all updating information as the hearing goes along. I bring this to the court's attention to point out the kind of absolute saturation of information that is going on. We get to the point where what's going on in these motions hearings, like a preliminary hearing, it's getting out into the public forum immediately. I want to bring also to the court's attention exhibit number 9. And this was a compilation of HLN live updates, also from the July 3, 2014 probable cause hearing, titled 10 Shocking Revelations in the Hot Car Death Hearing. Now, rather than pull it up, because I don't trust myself, I would just ask the court to take a look at that exhibit. And it's the same type of reporting I'm talking about, Judge, where it's sensational in nature based on the information that's being brought forth during the hearing. It's getting out into the public real time. And this information is out there. Analysts and talking heads are commenting on it. But this is how quickly it gets to the public. It's literally got a minute-by-minute update from the probable cause hearing. I want to bring to the court's attention also Exhibit 11. And Judge, that was in an effort, frankly, not to play some pretty shocking videos. I've given the court links to 3 videos that are on the internet. The first one is from YouTube or from HLN, and it discusses some information that came into the public arena via the search warrants. And it's titled Police, Both Parents Researched Hot Car Deaths. The next two are available either via HLN site or YouTube. One, Sexting, Just the Tip of the Iceberg. The other, Justin Ross Harris, Online Double Life Revealed. I bring these to the court's attention and ask that you take a look at them because I think it's going to give the court a very good flavor of the type of incredibly sensationalized storytelling that is going on on HLN and for all three of these sites anyway. CNN and HLN are everywhere, Judge. Not just in Cobb County and Georgia, but obviously everywhere in the country. These things that appear on these sites and then reproduced and passed around on the internet, it's part of the public domain. And what's happening is we have information, evidence, prosecution evidence that is coming out pre-trial. It is then being analyzed, dissected, discussed, and opinions are being offered on it. Opinions are being offered on guilt or innocence, and it's being done in a very dramatic format, to say the least. So I would ask the court to take a look at those as well. Let's see. Mr. Rodriguez, would you mind taking that down a little bit here? Judge, I think that gives you a very good idea of the information that's out there. Because it was disclosed in some form of pretrial manner, most notably the probable cause hearing. And I think we've demonstrated the oversaturation, the sensationalism that accompanies this release of information pre-trial, as well as the kind of commentary and discussion that comes with it. And that's where the problem is. I want to ask the court to take a look at Southeastern newspapers versus the state of Georgia, 265, Georgia 223. This is a 1995 decision. Supreme Court of Georgia concluded in this case, Judge, that closure for pretrial hearings, now it was a death penalty case, but it didn't have near the publicity that this case has. But in that particular case, Judge, there were apparently two articles, and based on those two articles, the Supreme Court of Georgia upheld closure. Relying on Lunkin, the very case that I gave you. And what the court found was that the standard had been met. The court noted that at the pre-trial stage, like we have here, there's less options the trial court did not specifically follow the edicts laid out in Lumpkin. The case that I went over with you that when I started, Judge, that is the roadmap. And what I've seen through these cases and taking a look at these Georgia cases is that the trial courts, they weren't following the directives in Lumpkin. One thing in particular that the courts have had a problem with was the failure of the trial court to very specifically consider and lay out why alternatives to closure would work. And so in this case, Judge, I want to go over with you real briefly what those alternatives would be and why they would be problematic. The first thing that the court has got to consider is, like I indicated, you can delay motions until a jury is selected and sequestered. Okay? Well, obviously there's a couple of problems with that. One, we have filed a demurrer and a number of motions challenging the seizure of evidence and statements, the joinder of offenses, constitutionality of statutes. But as I spoke to at the beginning, until you rule on those motions, there are a lot of other motions in limine that are not even ripe yet to be filed. And so that would create a real problem if the court were to hold off all evidentiary motions where prosecution evidence is discussed until we've already struck a jury and sequestered. Additionally, to bring to the court's attention, we've also filed a motion to sever offenses for improper joinder. Should the court grant that motion, and we've already selected and impaneled a jury, well, obviously, jeopardy would have already attached. We would have already voir dired all potential jurors on the now severed counts. And so it's an unworkable remedy at this stage. Additionally, depending on the outcome of pretrial motions, the parties, the state, as well as the defense, may have certain interlocutory appeal rights. And I will tell the court with all certainty, we do have some motions before the court that if we are not successful, we are absolutely going to make a request for interlocutory review. Those type, and it could very well be situations where the court deems that it really does need to go up. It absolutely needs to go up. Somebody's got to look at this before we go forward with the trial. Well, that's out the window if we've held everything until we've impaneled the jury and then sequestered them. So I would submit to the court that remedy, which is the preferred remedy discussed in Lumpkin, is not appropriate in this case. The second thing the courts require, alternative to closure the courts require to consider is change in venue. Well, we certainly do that occasionally in larger cases where there has been publicity. But I think as the court has seen and is clear, certainly anybody that has a TV, the publicity in this case is nationwide. We've got CNN, HLN, we've got everywhere. So I don't think that anywhere from Hiawassee to Hayhire there's going to be any difference in the coverage on those type of cable networks, Judge. So I believe that change of venue is not going to cure the harm which we're concerned with in this motion. The third thing the court needs to consider as an alternative to closure would be postponing the trial. There's no way of knowing what the interest in this case may be 6 months from now or a year from now. But in determining whether or not this is a sufficient remedy, I think the court can just look at the history of the case and see that in the 15 months since he was arrested, public interest does not appear to have waned. If you recall, this case was deemed by the Marietta Daily Journal the story of the year. On the anniversary of Mr. Harris's arrest, both the Atlanta Journal and the Marietta Daily Journal did a big one-year update on where the case is. And I would suggest to the court that intentionally delaying this trial for the sole purpose of seeing if public interest or media interest will wane is not reasonable, and certainly doesn't serve the interest of justice for either party. The fourth matter that the court should consider in determining whether it would be a sufficient alternative to closure would be a gag order on the press and public. This isn't addressed specifically in Lumpkin, but it is in some other cases. And certainly gag orders are something that courts do occasionally, rarely. But I think what we've shown the court through the evidence today is that would not be a sufficient remedy to ameliorate the problems of pretrial publicity and the disclosure that we discussed. I mean, let's assume that the court issues a gag order on the press, and I'm sure counsel will have a lot. They would argue substantially about that. But let's say that happened. Well, if we have an open courtroom is an open courtroom, and so that means anybody can walk in and out here, as they should be able to. Walk in and out of here, listen to the evidence, go right back out in the hallway, and put that information on their cell phone, get it on Facebook, and it's passed around. And that's why we showed you the Facebook link, so you could see that's exactly what would happen. You can't, if it's going to be an open courtroom, you can't gag the people coming in and out. That would be an unworkable situation, and obviously it would not cure the harm that we brought up to the court. Another matter that the court should consider as an alternative to closure is a searching voir dire. I believe one of the lawyers for the media suggested that this may be a more appropriate measure than closing the courtroom, and certainly we don't disagree that a very searching voir dire is. We don't suggest that's not appropriate. I think it's pretty clear that's going to happen in this case. We're going to have an opportunity to question jurors. And it's a good tool to determine to what extent they've had exposure to pretrial publicity, and to what extent they may have some fixed opinion about the case or about any particular piece of evidence. However, our position is that this is a unique and rare instance. There is a clear and present danger that without strong court measures here, curtailing the pretrial information into the public forum, there's not going to be the right to a fair trial. And I mean, if that's the case, Judge, essentially, I think the court would be saying, well, yeah, there may be clear and convincing evidence that there is such a danger, but what we're going to do here is we're just going to kind of wait and see how it goes. We'll let that harm occur, and then let's hope for the best. Let's hope for the best when we try to select a jury. I don't think that Band-Aid approach is appropriate under these circumstances, and I don't think that would cure the harm that we're concerned with. measure that court should consider as an alternative to closure are jury instructions. Well, I have no doubt that when the time comes, this board is going to give very thorough jury instructions, which will very likely include a very specific instruction that the jurors are to consider only evidence that came in the courtroom. That's not uncommon. But again, we've got the problem of that's really trying to unring a bell. If we've had juror exposure to matters which, again, like I said at the beginning, Judge, very well could be excluded on a number of grounds, suppressed on a number of grounds, limited, redacted. Do we knowingly allow that to come in and then try to unring the bell with a jury instruction? In our position, Judge, is that is just not reliant upon jury instructions in these circumstances to unring the bell and to jealously guard Mr. Harris's constitutional right to a fair trial. It's just completely insufficient. I have looked at and in a nutshell, Judge, that's what you need to consider. That's what we're asking you to consider, are those alternatives. And we believe that they're ineffective, but the court in Lumpkin has indicated that those have to be very specifically laid out. I have a proposed order for the court. Look before I hand it to the board. I'm going to read what specifically that we're suggesting would be appropriate. I'm asking the court to find that, to grant our motion for limited closure with these very, very specific limitations. That the defendant shall notify the court of any suppression or constitutional motion or motion limiting in which it is expected that prosecution evidence will be disclosed and discussed. There are some motions, Judge, that that's not going to be the case. In particular, there are some constitutional motions to mirror and whatnot that we don't think it's going to be necessary to discuss potential trial evidence. The court will reserve the right to require the defendant to make an ex parte proffer of what prosecution evidence he expects to be disclosed or discussed in any particular pretrial hearing. In other words, the court can call a bully. The court can call a bull if we say, Judge, this needs to be closed because we think it should be closed. Maybe the court should have the right to bring us in chamber and say, all right, well, tell me exactly what evidence you're talking about. I think that kind of safeguard would be a particularly effective measure to make sure that there is that closure is very limited and very narrowly tailored to effectuate, to ameliorate the harm that we're trying to do with this motion, Judge. For such pretrial matters, the courtroom will be closed to all individuals except the parties and counsel and essential courtroom personnel, sheriff's deputies, clerks, and so forth. The hearings will be recorded and transcribed. The cases speak directly to that, Judge. I know that counsel's going to get up here and suggest, well, we just don't do closure. We just don't do it. Well, the fact is that even the cases where closure was found inappropriate or not warranted, all of those cases recognize that closure does occur and is appropriate in limited circumstances. And each of those cases discuss how to limit any harm to the press and public. And one such way is that, hey, we're going to record and transcribe the motions. The parties nor the courtroom personnel will disclose or comment upon the evidence, argument, or court ruling during the closed hearing. The court will determine whether a written order on any pretrial motion shall be filed under seal until a verdict is reached. And I think that's a particular safeguard that the court obviously should have. Transcripts of any closed proceedings will be filed with the clerk of court and otherwise made available within a reasonable time following a verdict. All other hearings not otherwise specified herein, along with jury selection and trial, shall be open. That's what we're asking the court to do. I have had an opportunity to take a look at the responses from the lawyers for media, and I don't know that we really disagree with what the standard is, Judge. The media lawyers suggest perhaps some of the cases I cite have been distinguished. They're all good law. I haven't cited anything that's not good law. And so I think you can rely on the law that all of us have given you. It's all going to come down to whether the standards in the Lumpkin case have been met. The motion filed by Mr. Bauer, I would take issue with the suggestion that somehow the publicity is my fault because I filed pretrial motions, and that I have apparently acted as a puppet master and manipulated the media to our ends and then seek closure. I think that's unfair. I think it's inaccurate. I certainly have the right to make public comment when it's necessary to protect my client's rights from unfair pretrial publicity, and I've not been out there doing that. And so I think that's unfair. And more importantly, I think that's beside the point of what the court has to consider when applying the information that we've given you here today about the publicity and apply it to the standards in Lumpkin and the other cases. So that's our motion, Judge.
Proceed for the state.
Your Honor, as I'm sure we've been going for a while here, you don't want to have the standards read over and over again. I believe the media attorneys are going to cover that quite in depth, so I would defer and let them argue first, if that's okay with Your Honor, and save my comments until after they've addressed the legal standards they're opposed.
I'm sure they're not going to mind doing that.
I didn't think so.
Which gentleman cares to go first?
Your Honor, with your permission, I'll go first. Very good.
As long as y'all are back in.
No problem. Good morning, Your Honor. Again, I'm Tom Clyde. I'm here on behalf of the Atlanta Journal-Constitution and WSB-TV and WSB Radio and the Associated Press and CNN. I very much agree with defense counsel that the Page Court versus Lumpkin decision is a roadmap towards directing the court as to the standards that have to be evaluated in this case, I think where we disagree is where that roadmap ends. The court in Lumpkin made very clear that in the state of Georgia, open courtrooms, including pretrial hearings, is one of the cornerstones of our judicial system. As the court announced in that case, they said they believe that open courtrooms are the sine qua non of an effective and respected judicial system, which in turn is one of the principal cornerstones of a free society. The court went on to explain that because of the constitutional mandate in our state constitution that criminal trials shall be public, a trial court judge in Georgia has less discretion than a federal court judge would have in order to close pretrial proceedings. Really, three things came out of the Lumpkin decision. The first is essentially this issue that the trial judges in this state have less discretion. And I'm going to quote from the opinion because I think it shows how much emphasis the court puts on this issue. A Georgia trial court must approach these issues possessed of less discretion than his federal counterpart because our Constitution commands that open hearings are the nearly absolute rule and closed hearings are the very rarest exceptions. The other principle that came out is the standard that was articulated by Mr. Kilgore, and that is hearings shall be open to the press and the public on equal terms unless the defendant or other movement is able to demonstrate on the record by clear and convincing proof that closing the hearing to the press and the public is the only means by which a clear and present danger to his right to a fair trial can be avoided. So it has to be clear and convincing evidence, and it has to be a clear and present danger. It clearly involves a profound evidentiary showing to the court. And finally, as Mr. Kilgore indicated, the court requires that the trial judge not just consider, and that would be the standard at the federal level, but implement alternatives to try and remedy the potential prejudice. And so that includes change of venue, postponement of the hearing until after jury sequestration, searching voir dire, emphatic instructions to the jurors. So each of those is essentially a precondition to closing the courtroom. So where do we stand in this case based on that roadmap? As a threshold matter, there really hasn't been a showing of prejudice that is sufficient to meet the standard to even for this court to take a step of considering the alternatives to closure. And why is that the case? Essentially, the defendant has introduced a large number of newspaper articles that are posted online and published in a print edition. He's introduced synopses of television reporting and a number of links to CNN reporting, to HLN, other reporting. But as a basic matter, if the court goes through that, that reporting basically sets forth the procedural steps that have taken place in this case. The showing that's been made to date is basically trying to pick a few sentences out of those articles and try and suggest that they create a great sense of prejudice. Those sentences, when they're looked at in the context of the article, don't create that impression, especially when you look at the sequence of reporting. A lot of the comments that Mr. Kilgore focused on were initial comments made in the aftermath of the death of the child in this matter. And if the court recalls, essentially in that situation, this was initially thought to just purely be a tragedy, a tragic accident. And then slowly, it became apparent that the state of Georgia, through the Cobb County District Attorney's Office, thought that there might be significantly more going on. And ultimately, the state of Georgia took the position that this was premeditated murder of an infant, of a toddler. And that's where we stand today. Is that a shocking development? It is a shocking development. It was reflected as a shocking development in a case that was initially simply seen as a tragedy. But there's a difference between an unusual turn of events and prejudice. That unusual turn of events was accurately reported on the media. It also resulted in people expressing their opinions and commentary. But that is not prejudice. That is essentially a significant volume of reporting. But our Supreme Court has emphasized in the aftermath of the Page versus Lumpkin decision that that's not the inquiry. The inquiry is not the volume of reporting. Criminal trials, especially ones that arise out of unusual circumstances, will create a significant volume of reporting. But what the court says has to be the judge is prejudice. Prejudice that rises to the level of a clear and present its emphasis of Lumpkin and reversed a trial court that had approved the closure of pretrial proceedings. In the Rockdale decision, the Georgia Supreme Court emphasized these words: pretrial publicity, even pervasive adverse publicity does not inevitably lead to a fair trial. What has to be shown is prejudice. The court also emphasized that under our system, you're not entitled to a jury that knows nothing about your case. That's never been our system of justice. What you're entitled to is a jury that can put aside the knowledge it has and evaluate the case based on the evidence that's been presented. When you look at the records that have been submitted to the court, there is nothing so profoundly prejudicial in this case that could support a clear and present danger standard. But there's also another significant problem with the evidence, and that is the defendant is essentially focusing on past reporting that is already in the public domain as a result of the probable cause hearing that took place in that case. That information is going to remain in the public domain. The real focus of this hearing today should be on what is the potential, the supposed evidence in the upcoming hearing that supports the idea that somehow it could rise to the level of and support a showing that there is a clear and present danger to the defendant's right to a fair trial. There's been no showing at all, literally no showing at all this morning about what it is in these future hearings that could potentially create this and meet this standard. Essentially, defense counsel, as best as I can tell, I haven't seen his proposed order, but from how he's describing it, is saying the court should just enter a sweeping closure order now, and then in the future, there should be ex parte hearings in which the court evaluates whether to close a particular hearing in the future. Essentially, Your Honor, I think that reflects the showing today really hasn't been made to support any kind of closure, but it also, that request has the procedure wrong. The Lumpkin decision makes quite clear how this is supposed to work. If the defendant has at some time a feeling that upcoming testimony, upcoming evidence in a hearing is sufficient to meet the Lumpkin standard, then he should bring the motion to close. And if there's information that he wants to share with the court, that if it was disclosed would undermine the very reasons for closure, then he can go in chambers with counsel for the media, and we would examine that allegation in that context. In footnote 10 of the Lumpkin decision, it sets out that process. But instead, essentially what's being proposed today is that the court should sort of enter a generic, sweeping motion to seal future court hearings, and then on an ongoing basis evaluate it without media counsel being present. And I would submit that not only shows a showing hasn't been made today, that's quite contrary to the footnote that's set forth in Page versus Lumpkin about how this is supposed to go forward. Your Honor, during this issue that a showing really hasn't been made today was demonstrated when Mr. Kilgore essentially described that his suppression motion could include prosecution evidence that would be damaging to his client. That future in limine motions could include such information, that the court could redact recordings or statements, that there might be evidence that the court his motions could include evidence that the court would ultimately deem not relevant for purposes of trial. That is all speculation. Speculation is classically insufficient to close a courtroom, and the Georgia Supreme Court has said that many times. There would have to be some kind of concrete showing that rose to the level of a clear and present danger, and that simply hasn't occurred. What has occurred is essentially a presentation of straightforward news reporting that's included in the exhibits that have been submitted to the court, and then a presentation on the fact that in the modern system, news reporting takes place on a real-time basis. That's not an unusual development. Obviously, electronic media and the creation of the internet has allowed the media to deliver news information on a much faster basis. That news information sometimes leads to individuals in social media to express their opinions, to make speculation, but that has never been a basis to seal courtrooms, and in fact would be counterproductive. In other words, if this court were to seal courtrooms in the future, all that's going to do is lead to a great deal of speculation, a great deal of rumor on social media about what's being discussed in the courtroom. What are the issues that are being evaluated in the courtroom? In contrast to that, if the courtroom is kept open, then essentially straightforward news reports come out of that reporting, and the media and the public finds out about the way the judicial process operates in this system. That is essentially what the Lumpkin decision was encouraging. Your Honor, I want to turn also essentially to something that is a present here that is one of the major distinguishing features from the Southeastern newspaper case that's been given to the court. Cobb County is one of the most populous counties in the state of Georgia. It has a population of over 700,000 people. The authority the defendant is primarily relying on, the Southeastern newspaper case from 1995, involves Liberty County. At that point, the population in Liberty County was less than 60,000. And that is essentially what ultimately led to the Supreme Court quickly taking another case, the Rockdale Publishing case, and demonstrating that this is not open season on closure. Here, there is an enormous jury pool available to the court to pick a jury that is capable of rendering a verdict in a fair and even-handed fashion. And the truth is, in the metropolitan counties, and the counties around metropolitan Atlanta, which all have significant populations, there has never been closure of pretrial proceedings prior to a high-profile major trial since the Southeastern newspaper's case. And Mr. Kilgore said that this is a unique and rare situation. I would certainly agree that this is a high-profile matter, but it is not unique and rare. There have been many, many high-profile cases handled by the courts in the metropolitan Atlanta area in an open and public way. In DeKalb County, the trial of Sidney Dorsey after the assassination of Derwin Brown was an extraordinarily high-profile criminal proceeding, and it took place in a completely open way. There was no closure of pretrial hearings. In Fulton County, the trial of Brian Nichols for the courthouse shooting was again a case with enormous public attention. I would submit to you that both the Sidney Dorsey case and Nichols case were significantly higher profile cases than this. Again, there was no closure of pretrial proceedings. The courts rejected those motions. Cobb County has had its fair share of high-profile cases. The Lynn Turner case over antifreeze murders was a very high-profile cases. In all of these cases, changes of venue got considered. In some of them, changes of venue were pursued, but in none of them was pretrial hearings closed to the public, and that is consistent with Lumpkin. The change of venue has to be a remedy used prior to closing pretrial proceedings. Even in the social media environment, there's continued to be high-profile cases that are handled without the closure of pretrial proceedings. The Snyderman case, really two cases involving the Snyderman just took place in DeKalb County. There's also been a recent prosecution in DeKalb County of that county's former CEO. Again, no closure of pretrial proceedings. The fact that social media exists hasn't changed the standard and hasn't changed the ability of the court to properly seat a jury and handle these issues with a searching voir dire, strong instructions. So, Your Honor, we would submit that the two important steps that are defined by the Page versus Lumpkin decision have not been met in this case. First of all, there hasn't been a showing sufficient to meet the clear and convincing standard. I would submit that the idea that the defendant should be allowed to make some kind of ex parte proffer in the future is a concession that they haven't made the showing today that is required to seal hearings. And what's also clear is that it's not really, at this point, even clear what hearings the defendant is asking to close. A great deal of the hearings that are currently before the court involve essentially challenges to some of the charges arising from alleged sexting in connection with the right of privacy. That is essentially a debate about constitutional issues and the reach of our constitutional right of privacy and the charges that are lodged against him. That is classically a discussion that can take place in open court. The motion to sever charges is again also an issue about how connected these charges are. Those are hearings that should take place in open court. With respect to the other motions, there's been no articulation anywhere of what it is that creates the clear and present danger. So we would submit that they haven't met the extremely demanding standard articulated in Lumpkin. And then they haven't, because we don't really even know what hearings the defendant is seeking to close, then it's impossible to evaluate, even if we were to reach that point, it's impossible to evaluate whether alternatives are available. A sweeping closure motion over undefined future hearings makes it impossible to really evaluate that standard in any serious way. I would submit that, in truth, it's clear that a change of venue in this case, I think the court will be able to seat a jury in this county because of its significant population. But a change of venue would certainly remedy, if there was a problem, would certainly remedy the issue just as it did in other cases in the past, just as it did in the Lynn Turner case. And that is a step that the court's required to take before it closes pretrial proceedings. Your Honor, finally, I'd just like to emphasize much of the information that the defendant has focused on today is information that came out in the probable cause hearing. That information is out in the public record. It will remain in the public record. Sealing cases, sealing hearings in the future is not going to make that information go away. Sealing hearings in the future is simply going to create a great deal of uninformed speculation based on that information about what's occurring in the courtroom. This courtroom showing how it handles the allegations in this case, how our justice system decides what is sufficiently probative to be included in the evidence at trial, demonstrates to the public how we operate in an open and public fashion and how we sift the evidence in this case in order to put the state to its burden of proving its case beyond a reasonable doubt. I would submit that sealing the courtroom is simply going to be counterproductive to trying to put this case in the best possible position to be tried on a reasonable schedule. Thank you, Your Honor.
I think what we need to do is break until 1:30.
Your Honor, I only need 5 minutes.
We have 5 minutes, that's it.
Thank you. Given Mr. Clyde's excellent presentation, what he said largely would like to be adopted by WXIA.
No, why don't you just say that?
No objection.
I hope I just did. I do want to make 3 quick points.
Yes.
First, with respect to Mr. Kilgore's comment regarding an issue raised in our briefing for WXI and WGCL, the issue isn't that Mr. Kilgore's, it's his fault that this case has such a high profile or has attracted such publicity, and that's not what our brief was intended to suggest. But it was ironic that Mr. Kilgore did put up on the video a Facebook feed to show the court how prolific social media has been, but he scrolled past the very first entry on that page, which was a shared article about this case, and in fact about this hearing, by Lawrence Zimmerman, who's the attorney for the defendant's wife. And the point is that both the defendant, through his counsel, who at one point, I understand after the probable cause hearing, invited AJC attorneys to review case files in order to generate news articles to combat some of the information that was unfavorable after the probable cause hearing that was being reported on. There has been a clear effort by the defendant and his counsel to participate in shaping public opinion about the case. And as Mr. Kilgore correctly said, that is entirely within his right to do so. But as a matter of public policy, given the legal standards that Mr. Clyde so eloquently laid out for the court, it would be a terrible rule indeed if a defendant could make affirmative use of the media to shape public opinion about his case and then claim that that very media attention to the case is a basis from which to preclude the public from further access to key pretrial proceedings. He talked about these pretrial motions, and as Mr. Clyde referenced, none of the motions that actually could arguably present a clear and present danger have actually been identified, and all the motions that are on file have been public and on file for a year. And the defendant's counsel pointed to no media reporting about those motions that could suggest that anything prejudicial has been reported because of those motions' presence on the docket. Notably, he omitted all the favorable reporting that has been elicited by defense counsel's efforts or by efforts of the defendant's family and friends over the last year in his recitation of the harm. But primarily I want to take issue with 2 things. Number 1, the quantum of evidence. Mr. Clyde said that there's been no presentation rising to a clear and convincing standard of proof, that there's been a clear and present danger. There are mechanisms that were available to the defendant to make such a showing if he cared to do so. He could have surveyed the jury pool in Cobb County, he could have surveyed beyond the county borders and presented information to actually demonstrate a clear and present danger. Instead, he's asking you to assume that it exists. And the law doesn't permit that kind of assumption in this kind of case. And then second, the suggestion that this is really a rare and unique case. Mr. Clyde gave you some local examples. We cited in our brief the Timothy McVeigh case, which is frequently cited by courts around the country for the proposition that you can very effectively, even in the highest profile case, with the most pervasive media attention, when everyone can fairly say that the media's reporting had been highly negative with respect to the defendant's potential defenses to be raised at trial, even in those types of cases, which has captured the interest not just of Cobb County or Georgia or the nation, but the world, searching voir dire and strong and clear instructions by this court are the appropriate remedies. And I did not hear Mr. Kilgore articulate any reason, any sincere reason why those remedies could not be appropriate. For that reason, and for the reasons articulated by Mr. Clyde, my clients WXIA and WGCL would ask the court to deny the motion. Thank you.
Thank you, Mr. Bell. We are going to recess until 1:30. Everyone have a good lunch.
argued that pretrial publicity will make it possible, or impossible rather, for Ross Harris to get a fair trial. Fox 5's Angelique Proctor is live in Cobb County with the very latest for us. Angelique?
Good afternoon, Lisa. Let's face it, this case has gotten intense publicity, not only locally, but nationally. And Ross Harris's attorneys say because of all of that coverage, or in their words that they use, sensationalism and false reporting, they want to now kick cameras out of the courtroom, at least for the pre-trial motions hearings, which will be going on all this week. Now, Maddox Kilgore is the attorney for the Cobb County father accused of intentionally leaving his toddler son Cooper in that hot car back in June of 2014. The attorney says if the courtroom remains open, evidence and information in the case will be analyzed, dissected, and discussed in real time on cable news outlets, poisoning jurors before they are ever selected.
Here, if measures are not taken to curtail the disclosure of everything, this case is absolutely going to be tried in the media and in the court of public opinion.
Now, this is one of 14 defense motions. These motions will be heard all week. We've just been listening to one this morning, so we will let you know what the judge decides if she plans to kick those cameras out of the courtroom. Reporting live from Cobb County, Angelique Proctor, Fox 5 News.
Thank you, Angelique. Well, on to a much lighter note. If you didn't get the chance to spend some time outside yesterday, bah humbug. We're in a repeat for that same type of gorgeous weather. We're going to check in now with Fox 5 Storm Team meteorologist Jeff Hill. It was absolutely beautiful, spectacular, phenomenal, gorgeous.
If you didn't get a chance yesterday, play hooky today and get outside and enjoy it. Beautiful afternoon, lots of sunshine, low humidity, and the pleasant temperatures continue. Let's take a look at what's going on outside right now. Bright blue sky over downtown Atlanta, hardly really anything going on, just the sun passing overhead. We're going to continue to have a beautiful afternoon and a beautiful evening. We should see temperatures later on tonight getting cool, but maybe not as cold as it was this morning. Take a look at some of these lows early this morning, especially up in the North Georgia mountains. 45 in Blue Ridge, got down to 40 up in Tiger. 43 was your low this morning in Ellijay. 47 in Dahlonega. 43 over in Calhoun, and it got even colder up in Blairsville. Got down into the 30s. 39 there. We hit 54 here in Atlanta. It was 47 down in Peachtree City. 51 in Gainesville. Marietta, you woke up to 49. You woke up to 44 over in Rome. Current temperature right now 70 degrees. Dew points at 50. Absolutely beautiful day. East southeast wind right now at 8 miles an hour. Humidity 49%. Here's a look at some other temperature readings. 69 up in Jasper. 68 in Gainesville. 71 over in Athens. 68 in Griffin. 68 in Noonan. 73 down in Thomaston. 76 the warm spot in LaGrange, but we can take that. Here's a look at the forecast as we go through the overnight. We'll get down to about 59 early tomorrow morning. Tomorrow's afternoon highs similar to today. We'll get back into the upper 70s, low 80s. Humidity stays low, but it looks like that'll all start to change a little bit as we head through the rest of this week. So we'll take a look at that in more detail. And the Falcons forecast, they're playing tonight. It's going to be a great night to great evening to tailgate. More on that in a few minutes.
And to rise up, of course. All right, thanks, Jeff. The man accused in a string of violent attacks against women in East Point went before a judge this morning, facing the first in a long list of charges. Fox 5's Deidre Dukes is live in East Point. And Deidre, this suspect faces sexual assault charges but was in court today for theft.
That's right. He was arrested on Friday, and Terry Young faces some very serious charges. But Lisa, he showed no emotion in court as he appeared before that judge today. Sex assault suspect Terry Young in court on theft charges Monday morning, making his first court appearance since police arrested him in connection with a series of recent sex assaults in East Point at the Highwood Park subdivision. Young was arrested on Friday, just days after police released this video captured by a nanny cam of the suspect during a sexual assault at a home last week. 2 women were kidnapped and sexually assaulted by a gunman last Monday, just a week after a similar attack at the same townhome complex on September 4th. In that incident, a Creekside High School teacher was carjacked at the complex, groped, pistol whipped, and forced to go to an ATM. The victim jumped out of the vehicle, escaping the suspect at the Wells Fargo on Kemp Creek Parkway. The suspect, we understood in court, will be back in court tomorrow on home invasion charges. We're still awaiting word as to when he will face sex assault charges in court, when he will make his first appearance on those charges as well. And that's the latest here in East Point. I'm Deidre Dukes, Fox 5 News.
Deidre, thanks. A teenager is in the hospital after he was wounded in a drive-by shooting in southwest Atlanta. The gunfire also hit homes on Windsor Street on Saturday night. Police found the victim about a half-mile on Fulton Street. They aren't sure how he got there after the shooting. Police are working to determine if he was the intended target or an innocent bystander. Fire crews say a smoke detector helped save a family from an early morning fire. Firefighters were called to the scene at Benjamin E. Mays Drive in southwest Atlanta around 12:30. They found smoke and flames coming from the home when they got there. The fire displaced 2 adults and 1 child, but they all got out unhurt. Terrifying few hours for an Alpharetta family overnight. Their 7-year-old daughter left home after a disagreement with her parents. She was found after an intensive search. Fox 5's Caitlin Pratt has more on the effort that led to a very happy reunion.
Certainly something to smile about this morning here in Roswell. That 7-year-old is home, safe and sound. Scared and whimpering, a little girl is carried to her family, a family frantic to get her home. Dressed in only pajamas, Dayanara Peregrino left her home angry after a disagreement with her parents Sunday.
She ran away, and I guess the parents thought she would come right back, you know, and she didn't.
Sun went down, worry escalated.
It's really getting cold out, it's dark.
Tracking dogs, officers, firefighters, all searching the woods near Dasso Court in Alpharetta.
He has appreciated everybody that's been helping him with this searching with his daughter.
The 7-year-old's picture put out on social media, and 5 hours later, relief.
It's okay, darling.
In a dark corner of her neighborhood, the search party coming to a close. And that little girl was checked out shortly after the reunion by paramedics there at the scene. She is okay, police say, just scared and cold. That's the very latest here outside Roswell Police Headquarters. I'm Caitlin Pratt, Fox 5 News.
A Gainesville church hit by vandals over the weekend, and police are working to track down whoever is responsible. Someone spray painted vulgar and racially charged graffiti on the walls outside the First Baptist Church over the weekend. A church member painted over the disturbing words, but the incident shook the congregation. Gainesville police ask anyone with information in this case to please give them a call. Coming up, forced from their homes by unimaginable violence, they seeking a better life by any means necessary. Now the migrant influx forces European leaders to hold urgent talks on action to address the crisis. But first,
for me, this would be an act of disobedience to my God. While there are many accommodations available,
the county clerk jailed for refusing to grant same-sex marriages licenses is back on the job and still standing her ground. The county clerk jailed for refusing to issue same-sex marriage licenses is back at work. A federal judge held Kim Davis in contempt after refusing to issue licenses to same-sex couples despite an order from the Supreme Court. Now, Davis says her name will no longer appear on licenses issued in Rowan County, Kentucky. Instead, the licenses will say they are issued pursuant to federal court order.
To affix my name or authoritative title on a certificate that authorizes marriage that conflicts with God's definition of marriage as a union between one man and one woman violates my deeply held religious convictions and conscience. For me, this would be an act of disobedience to my God. While there are many accommodations available, a very simple accommodation I have proposed is to remove my name and my title as the clerk of Rowan County completely off the marriage license. These licenses could be issued under another authority, including perhaps the Commonwealth of Kentucky or Governor Beshear himself.
After making her statement this morning, Davis went to her office and stayed there with the door and blinds closed. New poll continues to show presidential candidate Donald Trump ahead of his Republican rivals. Meanwhile, the trouble continues for Democratic presidential candidate Hillary Clinton as her support drops. Fox's Caroline Shavley breaks down the latest polls.
Hello, everybody. Whoa,
a new national poll shows real estate mogul Donald Trump garnering 33% of voters, followed by retired neurosurgeon Ben Carson at 20%. Former Florida Governor Jeb Bush leads the rest of the field, but with just 8%. Trump says he knows why.
We have stupid leadership.
That could be the one thing that he and surging Democratic presidential candidate Bernie Sanders agree on.
You are looking at one of the very few candidates for President of the United States who does not have a super PAC and does not want a super PAC.
This weekend, the independent Vermont senator drew large crowds to events in North and South Carolina. Sanders still trails former Secretary of State Hillary Clinton, but is now leading her in New Hampshire, the first primary state. 42% of Democrats and Democratic-leaning independents back Clinton to Sanders' 24%. Vice President Joe Biden, who's still not even in the race, has 21%. This is the first time the former Secretary of State has dipped below 50% in this poll. She spoke at a D.C. church this weekend and says she'll follow her faith in the race.
But it's a great reminder that I carry around with me to try to get me back focused when life and its vicissitudes sometimes knock you off the path.
Mrs. Clinton also got some advice from the pastor. You've got to be nicer to the press. She said she will certainly take that to heart. In Washington, Caroline Shively, Fox News.
Oh, Jeff, I'm going to say it again. Yesterday was glorious.
Nice.
So we're going to have another glorious day, right?
Glorious, yes.
Yes.
Yesterday's high was 75. I think today will be just a little bit warmer. The good news is the humidity stays nice and low. It's going to stay that way right up until about Wednesday, and then we'll start to see that humidity slowly creep back in. Let's take a look at what's going on out there. I've got the football forecast. Falcons tonight. Falcons-Eagles. Could be a great night down at the Dome, and it looks like temperatures will be around 75 degrees if you're down there tailgating. It's going to be a beautiful evening for that. End of regulation, about 66 degrees as you file out of the Georgia Dome. Again, Falcons-Eagles right around 7 o'clock kickoff this evening. Here's a look at the radar and cloud composite. Really nothing to look at because we don't have any cloud cover overhead. We're not really going to see any clouds today or tonight. Really won't even see any moisture returning, I think, until about Wednesday. We'll start to see some cloud cover come back up out of the south. But high pressure sitting on top of us, giving us lighter winds today than what we saw yesterday. Yesterday was a little bit blustery. Still had a little bit of wind in the overnight hours, but pretty much light winds, I think, for most of today into tonight. Here's a look at the hour-by-hour forecast. We've seen a shift in the wind flow. Yesterday was northwest. Today we're coming in more out of the east and southeast, and what that will eventually do is bring back a little bit of moisture coming up out of the Atlantic and then eventually up out of the Gulf as we head into Wednesday. But really nothing coming our way here in North Georgia except maybe a few high clouds. Wednesday, the clouds thicken a little bit from Atlanta to the south. The rainfall, though, stays south of Macon. Portions of South Georgia will see some rain on Wednesday. We won't get any of that here. up in North Georgia. As far as the amount of moisture goes, the dew points, which factors in with the humidity, look at how low they stay. When they're in the 40s and 50s, that's when it feels so great, like it feels outside right now. And it's going to stay that way through Tuesday. But notice on Wednesday, the numbers start to come back up into the upper 50s and low 60s, and eventually I think we'll all see the dew points back into the 60s heading into the weekend. So that means things are going to get a little more humid, and it's going to start to heat up a little bit too heading into this next weekend. High temperature yesterday, 75, got down to 54 this morning. 79 will be the high later on this afternoon. Can't beat that at all. 70 outside right now. Dew point still low at 50. East-southeast wind at 8 miles an hour. High temperatures, the temperature we have right now so far, and 54 was the low this morning. Here's a look at some current temperatures around the region. We go up toward Calhoun. We got 68 there, 66 in Clayton, 71 in Athens, 72 in Edenton, 73 in Zebulon. Don't you wish it could be this way every day of the year? 69 over in Carrollton, 72 in Barnesville, 68 up in Dawsonville, 69 over in Canton. So highs this afternoon. Here in Atlanta, we get up to about 79, maybe a couple of 80s showing up down to the south. And then lows overnight tonight, still pretty cool, but not as cold. 53 in Canton, 59 here in Atlanta. Storm Team AccuWeather forecast this afternoon, sunny and pleasant. High of 79. Then for tonight, we'll see the temperatures drop off into the upper 40s and upper 50s. And the extended forecast high of 82 on Tuesday, 81 on Wednesday. And again, temperatures heating up a little bit, but we never get any rainfall. We just stay mostly sunny. Highs eventually back into the mid to upper 80s with those overnight lows. A little more humidity will keep the lows down into the upper 60s. Gotta love it. Lisa?
Oh, love it, love it, love it. Thank you, Jeffrey. Later this hour, prescriptions for ADHD medications have soared in the last decade and are often used by people without a prescription. Now, a new app promises to improve your focus without the drugs. But first, how do they handle an influx of 1 million people? European leaders holding urgent meetings to take on the migrant crisis before it grows larger. Could it be a turning point? Today, European leaders are holding urgent meetings to address the migrant crisis and find ways to provide a new life for thousands of refugees. Fox's Greg Palkut has more from Hungary.
Tighter security on the German border with Austria. Berlin reintroducing security checks there to help control the flow of refugees who are still being allowed into the country. German officials now expect to welcome 1 million migrants this year, a 200,000 increase from the previous estimate.
Germany clearly cannot manage this burden alone. That is why we've been saying for the whole summer to the Italians, the French, the British, and all the others, we must introduce a real responsibility sharing.
More than 19,000 migrants arriving in Munich over the weekend, many of those hoping to go to Germany, traveling through Hungary and Austria. Vienna tightening up its border with Hungary in an effort to better manage the influx.
An orderly crossing and an orderly entry into a country is no longer happening. This is why, in this emergency situation, we are forced to act accordingly.
Refugees still pouring into Hungary, where officials are less welcoming. The government here building a 13-foot-high fence on the border with Serbia and increasing patrols, hoping to keep people out.
Hungary is a country with a 1,000-year-old Christian culture. We Hungarians don't want the global-sized movement of people to change Hungary.
New laws going into effect tomorrow will allow Hungarian police to arrest migrants who breach this border fence, and that could lead to jail time or deportation. On the border between Hungary and Serbia in Raška, Greg Malcott, Fox News.
Coming up, sometimes we all need that reminder to celebrate ourselves. We'll show you how a photographer is out to prove to all women that they are beautiful inside and out. But first, Pope Francis preparing to come to the U.S., and security ramps up in response to some very real threats. We have some breaking news into the Fox 5 newsroom. Officials at Delta State University of Mississippi have locked down their campus after reports of an active shooter on campus. The university just sent these tweets minutes ago. The first tweet states, "An active shooter has been spotted on campus near Jobe Hall. Please take immediate lockdown action." The most recent tweet says, "The campus remains under lockdown. Please stay inside and away from windows." We are hearing reports of out of Mississippi of at least one gunshot victim. Delta State is in Cleveland near the Mississippi-Arkansas line with around 3,500 students. We'll bring you any updates as soon as we receive them. Police say officers have shot and killed a man accused of killing a Kentucky State trooper. Investigators say police shot 25-year-old Joseph Thomas Johnson Shanks when he refused to drop his weapon this morning. Authorities say 31-year-old trooper Joseph Cameron Ponder pulled over a driver for a traffic stop last night. The driver took off, and after a chase, police say he fired several shots at Ponder's cruiser. Pope Francis is set to arrive for his first ever visit to the United States next week. The chairman of the House Committee on Homeland Security says there's been at least one threat against the Pope, but he also says authorities will be vigilant to protect him during his visit to our country. The Pope will visit Washington, D.C., then New York, and finish in Philadelphia. It isn't clear where this threat was based. Coming up, improving your concentration skills with something as simple as an app. We're going to show you how new technology promises to give people the edge without the meds. But first, think about this for a second. When was the last time you had a professional picture made of yourself? Next, the inspiration behind a photographer's mission to make sure every woman knows she's beautiful.